You just got divorced. Rewind a few months though, because that's really where this story starts. Not in a courtroom, but on an ordinary Tuesday evening. Dishes in the sink. A conversation that's been circling for years finally landing somewhere neither of you can walk back from. There's no dramatic scene, no shouting, just two people admitting quietly that this is actually happening. A few months later, you're sitting across from a lawyer you never expected to need, signing a stack of paperwork that's about to touch nearly every part of your financial life at once. You just got divorced. Most people sitting in the chair you're sitting in right now assume the same thing. Divorce means splitting everything 50-50, down the middle, and moving on. That assumption is only true for a fraction of the country, and understanding why is about to change how you see the next several months of your life. Here's the first thing almost nobody realizes going in. There is no single national rule for how property gets divided in a US divorce. Only 9 states, including California, Texas, and Arizona, follow what's called community property law, where everything acquired during the marriage is presumed to be owned equally and split essentially 50-50, no matter who earned it or whose name is on the title. The other 41 states, plus Washington, D.C., use something called equitable distribution instead, which sounds similar but works very differently. Equitable doesn't mean equal. A judge in one of these states divides property based on what's fair, weighing things like how long you were married, each person's income and future earning potential, who sacrificed a career for the household, and even, in some states, whether one spouse wasted or hid marital assets. Two people with an identical house, an identical retirement account, and an identical income gap could walk away from their divorces with completely different splits, purely because one lives in Ohio and the other lives in Texas. But here's where things get interesting, because property division is really just the opening chapter. While you and your attorney are working through who keeps the house, something else is quietly happening in the background that most people don't think about until it's almost too late. Your health insurance. If you were covered under your spouse's employer plan, that coverage doesn't just get renegotiated when the divorce finalizes, it ends. Immediately, federal law gives you a narrow 60-day window to elect COBRA continuation coverage, which lets you keep the same plan, but at a price that often stuns people. You now pay 102% of the full premium, both the portion you used to pay and the portion your spouse's employer used to quietly cover, which for many people had been absorbing 70 to 80% of the real cost. Individual COBRA coverage in 2026 typically runs somewhere between roughly $500 and $800 a month. Family coverage often between $1,500 and $2,000, and it's available for up to 36 months. Miss that 60-day window, and you may be left with no continuation option at all, forced into the ACA marketplace instead, where subsidies can help but only if your new post-divorce income actually qualifies. Unfortunately, that's not the only clock running. If retirement accounts are part of what's being divided, a 401k, a pension, anything built up during the marriage, you can't simply write a check or transfer the funds like a normal account. Dividing a retirement plan in divorce requires a specific legal document called a Qualified Domestic Relations Order, or QDRO, a mechanism created by federal legislation back in 1984 specifically so courts could direct plan administrators to split these accounts without triggering early withdrawal penalties or a surprise tax bill. Here's what most people don't realize until real money is on the line. Attorneys and financial advisors routinely draft these incorrectly, and a poorly worded QDRO owe can get rejected by the plan administrator, delaying the transfer for months. Or worse, accidentally trigger taxes and penalties that a correctly drafted order would have avoided entirely. This is exactly the kind of paperwork detail nobody warns you about at the start, and it can quietly cost thousands of dollars if it's handled by someone who doesn't specialize in it. Meanwhile, if there are children involved, a parallel financial system kicks into motion almost immediately. Child support. Most states now calculate this using something called the income shares model, which combines both parents' incomes, factors in the parenting time split, childcare costs, and each parent's access to health insurance, and produces a number neither of you gets to simply negotiate away. In New York, for example, the formula runs roughly 17% of combined parental income for one child, up to a set income cap. In Texas, it's calculated closer to 20% of the paying parent's net income, with its own separate cap. These formulas vary significantly by state, and the number that comes out the other end is often far more rigid and far less negotiable than people expect walking in. This is where a decision most couples don't think carefully enough about starts to matter. Spousal support, sometimes called alimony or maintenance. Unlike community property or child support, which often follow fairly rigid formulas, spousal support is one of the more flexible and contested pieces of a divorce. Factoring in the length of the marriage, the income gap between spouses, and each person's ability to become self-supporting. It's also one of the areas people most commonly misunderstand. Many assume it's automatic or permanent, when in most states today, it's neither, often structured to taper off or end entirely once the receiving spouse remarries or becomes financially independent. There's another problem lurking underneath all of this that catches people completely off guard. Taxes. Dividing property doesn't always happen tax-free. Selling a jointly owned house as part of the settlement can trigger capital gains taxes depending on how much the home has appreciated since it was purchased. Splitting investment accounts, unless it's done correctly, can create a taxable event neither of you budgeted for, and your filing status itself changes the moment the divorce is finalized, which can shift your tax bracket, your standard deduction, and what you owe the following April in ways that are easy to overlook while you're focused on the emotional weight of everything else. Now, about the actual cost of getting here in the first place, because that number surprises people too. Filing fees alone typically run somewhere between $200 and $400 depending on the state, but that's the smallest piece of the picture. Attorney fees, especially in a contested divorce where custody, property, or support is genuinely disputed, can push total costs into the tens of thousands of dollars once both sides account for legal fees, appraisals, and the time it takes to resolve everything. Figures that vary enormously depending on how much you and your spouse can agree on versus how much ends up decided by a judge. There are a handful of mistakes that quietly cost people real money in exactly this situation, and almost none of them are obvious in the moment. Hiding or undervaluing assets is not only unwise, it's illegal in every state and can blow up a settlement if discovered later. Missing the 60-day COBRA or a marketplace enrollment window can leave you with a dangerous gap in health coverage at the worst possible time. Letting a generic attorney draft a QDRO without specialized experience can cost thousands in rejected paperwork and tax penalties. And one of the most commonly overlooked mistakes of all, forgetting to update life insurance beneficiaries, retirement account beneficiaries, and your will after the divorce finalizes, which can mean an ex-spouse legally remains entitled to assets you never intended them to receive. So here's how this actually plays out. Handled well, property division understood under your specific state's rules, health insurance secured within the 60-day window, a properly drafted QDRO for any retirement accounts, and every beneficiary designation updated the moment the ink dries. This becomes a genuinely difficult but financially survivable transition, exactly the kind of restructuring the legal system, however imperfectly, was built to manage. Handled poorly, assets hidden or undervalued, a missed COBRA deadline, a rejected QDRO, an ex-spouse still listed on a life insurance policy years later, and the same difficult conversation from that ordinary Tuesday evening can echo through your finances for years after the papers are signed. You're sitting there now with the signed decree in front of you, and the marriage itself is officially over. But almost everything that happens to your finances from this point forward, your health coverage, your retirement savings, your tax bracket, who gets what and when, was decided by a set of rules that existed long before you ever needed to learn them. Rules that vary more by which state you live in than most people ever realize until they're the one living through it.